Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law number 2 of Jefferson County, Texas. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law number 2. You have been asked to come here this morning for what is called an arraignment. And what the arraignment is, it's an opportunity for the court to tell you what you've been charged with, what your options are, and what your rights are concerning your case. The case that you have in this court is a misdemeanor case. Criminal cases are divided into felonies or misdemeanors. Your felony cases are your most serious type cases, and your misdemeanor cases are normally referred to as your petty offenses. It does not mean that they're not serious. It just means that the punishment range is not as high as the felony offense. If you had a felony offense, then it would either be a capital murder, first-degree felony, second-degree felony, third-degree felony, or a state jail felony. And the range of punishment, if you are convicted for either one of those categories, are as follows. For a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail and a fine up to $10,000. For a second-degree felony, the range of punishment is for third-degree felony, the range of punishment is minimum 2 years to 10 years in the state penitentiary, a fine up to $10,000. For a second-degree felony, the range of punishment is minimum 2 years to a maximum of 20 years and a fine up to $10,000. For a first-degree felony, the range of punishment is minimum 5 years to a maximum of 99 years to life, fine up to $10,000. And for a capital murder case, the range of punishment is life or death. Now, we do not handle felony cases in this court. We only handle misdemeanor cases. Misdemeanors are divided into 3 categories: a Class A, Class B, and a Class C. And the range of punishment, if convicted, are as follows. For a Class C misdemeanor, it is a fine only. Now, your Class C misdemeanors are normally cases that are handled in the city court, which is the municipal court, or the JP court, which is the justice court. And for example, a traffic ticket is a Class C misdemeanor. So you can't get jail time. You can only get a fine. Now, we handle Class C misdemeanors when they are appealed from the JP court or the city court. Now, for the Class B misdemeanor, the next highest misdemeanor above a Class C, the range of punishment is 0 days to 180 days in the county jail or anywhere in between, a fine from $0 to $2,000 or anywhere in between. Or you could be given both such fine and confinement. For a Class A misdemeanor, the range of punishment is 0 days to 365 days, which is a year in the county jail or anywhere in between, a fine from $0 to $4,000 or anywhere in between. Or you could be given both such fine and confinement. Now, you may qualify for probation. There are 2 types of probation. One type is called unadjudicated probation, and the other type of probation is called adjudicated probation. And the difference between the 2 are as follows. With an unadjudicated probation, if you are given unadjudicated probation, it does not result in a conviction on your record. And if you successfully complete it, you will not only have a conviction on your record, but you may qualify for non-disclosure. And what a non-disclosure is, it means that we cannot disclose to the public or tell the public that you are on unadjudicated probation for your offense. Now, however, if you violate your probation, the district attorney's office can file a motion to revoke your unadjudicated probation. and if they file a motion to revoke your unadjudicated probation, and if the court finds that you have violated your probation, the court can revoke your probation, and either they can continue on probation or they can kick you off of probation. And if they kick you off probation, you may get a conviction. If you get a conviction, obviously, it does result in a conviction on your record, and you will not be able to qualify for non-disclosure. Now, the other type of probation is what we call adjudicated probation. Adjudicated probation just simply means that you will have a conviction on your record.
Okay, yeah. All right, thanks, Jay.
Hold on. Mr. Grove. Yeah, Mr. Grove. David Grove.
Well,
Mr. Grove.
looks like I ought to be on, but obviously they can't hear me. Or I can't hear.
Mr. Grove, we can hear you, but you.
Oh,
can't
that's
hear us.
right.
Mr. Grove, can you hear me?
Yes, sir. Now I can. Thank you.
Okay, Mr. Grove, you represent Robin Purdue. That person has a case that, first of all, Robin Purdue is in jail, and that she has a felony case set today in drug court. So you do not have to make an appearance in this court on that case.
Yes, sir, Judge. I wasn't sure about that. I knew she had a felony case, but I will check with the DA, and I guess this will be reset the same day as her felony. Yes.
Now, if the felony gets disposed today, then our office, the court coordinator, will call your office to see if you want it set on the jail run.
Which will be yes, sir.
Okay.
And I just got a new case that was filed against her on Friday, so she now has two cases.
Right.
All right.
Okay.
Well, thank you, Judge.
Okay. You're free to go, and you have a blessed day.
Okay. Thank you.
Okay. You're welcome. Okay. Now, ladies and gentlemen, I had just told you about unadjudicated probation. If you complete it, does not result in a conviction on your record, and you may qualify for non-disclosure. However, if you violate it, your probation can be revoked, and if your probation is revoked, you may get a conviction on your record. If you get a conviction on your record, the case will not be dismissed, and you cannot qualify for non-disclosure. Now, the other type of probation that I mentioned was adjudicated probation. Adjudicated probation does result in a conviction in your record. However, there's something that is called judicial clemency, which means that the court can set aside that conviction. But a couple of things have to happen. First of all, the probation that you're on has to expire. You have to be successfully terminated from that probation. There cannot be any more time left on that probation. And if that's so, then the court can allow you to come back into court, withdraw your plea, and the court can set aside that conviction. However, if you get a subsequent conviction, then the state can bring the case back up. They can revive it or resurrect it and bring it back up. And if that's the case, you will have a conviction. You may get a conviction on your record. Now, if you get the non-disclosure, obviously, the court can set aside the conviction. Now, as a defendant in a criminal case, you have rights. Now, that paperwork that's been handed out to you, it talks about one of the rights that you have as a defendant in a criminal case. And one of the rights that you have as a defendant in a criminal case, you have a right to have an attorney. Now, regarding your right to have an attorney, you have three options. Number one, you may hire an attorney. Number two, if you do not have enough money to hire an attorney, you may request an attorney be appointed to represent you. Number three, you may represent yourself. If you want an attorney to represent you and you have enough money to hire one, the case will be reset to give you time to do so. If you want an attorney and do not have the money to hire one, you will need to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. You may not speak to the prosecutor. The prosecutor is the assistant district attorney. Actually, we have one sitting in court right now, but you can't speak to him about your case unless you sign a waiver of your right. And what a waiver is, you're saying that you're giving up your right to have an attorney and you will be representing yourself, okay? Now, if you do that, then you'll have a right to talk to the prosecutor. Now, be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you and your case, including the loss of significant legal rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to proceed without an attorney, that is, if you choose to represent yourself, you may change your mind at any time, and you may request counsel from the court. At the bottom of that document, it states in bold letters, defendant's choice. Mark initials next to only one choice. If your choice is, I want to reset this case to hire my own attorney, then you'll place your initials on the first line to the left. Now, reset means to reschedule. If you have already hired an attorney to represent you in this case, then you'll place your initials on the second line to the left and the name of the attorney on the line to the right. If your choice is, I want to apply for court-appointed counsel or court-appointed attorney, then you will place your initials on the third line to the left. If your choice is, or if you have already been appointed a court-appointed attorney in your case, then you would place your initials on the fourth line to the left and the name of the attorney on the line to the right. If your choice is, I want to waive my right, which is I want to give up my right to an attorney and represent myself, then you'll place your initials on the fifth line to the left. Once you have finished initialing one of the 5 lines, then you will sign your signature on the line that is titled defendant, and you will place today's date, September 13th, 2022, on the line that is titled date. Now, for those of you who will be waiving your right to an attorney or giving up your right to an attorney and you desire to represent yourself, you would have to read and sign the next document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea and Proceeding to Trial. And it reads as follows. I have been advised of the nature of the charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. Furthermore, I have been advised the 13th day of September of 2022 by the County Court at Law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I am unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed to me free of charge if I'm not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. And if that is your choice, then you will place your signature on the line that is titled defendant, and you will place today's date, September 13th of 2022 on the line that is titled date. Now, I don't know if you have a financial affidavit of indigence that's on the clipboard, then that will be filled out for those individuals who is applying for a court-appointed attorney. and you would have to fill out all of the information that is on page 1 and page 2. Now, as a defendant, and we'll give you time to do that at the end of the arraignment. Now, as a defendant in a criminal case, you not only have a right to have a trial by, you not only have a right to have an attorney, but you also have a right to have a trial by jury. And when those young people are sitting in that area, we call that the jury box. 6 citizens from Jefferson County will be selected to sit on your case, and they will deliberate, and they will decide, after listening to all of the evidence and deliberating, they will decide whether or not you are guilty or not guilty. You have a right to waive, which means to give up your right to have a trial by jury. And by doing so, your case will come before the judge in one of 3 ways. It can come before the judge by way of a trial, and that trial, we call it a bench trial. It's a trial by judge only. The judge will listen to the evidence and decide, after listening to all of the evidence and all the closing arguments, the judge will decide whether or not you're guilty or not guilty. The judge will also assess the punishment if you are found guilty. You also have a right, well, the other option that you have is, the way it will come before the court is by way of a agreed plea bargain. An agreed plea bargain, what a plea bargain is, it's an agreement that you make with the state to settle your case. You and the district attorney come to a settlement in your case. We call that a plea bargain agreement. If you reach a plea bargain agreement, then the case will come before the court and come before the judge, and the judge will decide whether or not to follow or not follow the plea bargain agreement. When I say follow, to go along with the plea bargain agreement, or to accept it, or to reject it, the plea bargain agreement. If the judge does not follow the plea bargain agreement, and if your plea bargain, and if it's rejected, then you will be entitled, or you will have the right to take back, or you have a right to withdraw, which means to take back the plea bargain agreement. Now, if the judge follows the plea bargain agreement, if you decide within 30 days that you would like to appeal your case, in essence, what an appeal is, you want a higher court to look at your case to see whether or not you have been wrongfully convicted, or whether or not the court committed an error by convicting you, then you have to get permission from the judge to appeal the case if the judge follows the plea bargain agreement. Now, the other way your case can come before the judge is by way of an unagreed plea bargain agreement. Unagreed means that you and the state have not been able to reach an agreement concerning the settlement of your case. And you want the court to decide what the punishment will be in your case. We call that an unagreed plea bargain. Now, if you have an unagreed plea bargain, you don't know ahead of time, the judge will assess punishment within the punishment range of the offense. You also have a right to have witnesses to come to court to testify. You have a right to have witnesses. Witnesses sit in that chair to my left, we call that the witness stand. And they can testify either for you or against you. You can ask them questions if you're representing yourself. You have a lawyer, your lawyer can ask them questions. We call that direct examination or cross-examination. You also have a right to waive or give up your right to have a trial, to have witnesses to come to court. And by doing so, it just simply means you will not be calling witnesses to testify in your case. It does not mean that the state will not be calling witnesses to testify in your case. You also have a right against a Fifth Amendment right against self-incrimination. What that means is you have a right not to testify in your case, and the state cannot force you to testify. When I say the state, I'm talking about the district attorney's office. They cannot force you to testify against yourself in your case. Now, you have a right to waive your right, your Fifth Amendment right against self-incrimination. And by doing so, if you waive your Fifth Amendment right against self-incrimination, you will be testifying in your case. You also have a right to have what we call discovery. That is, you have a right to see the evidence that the state has against you in your case. In essence, you have a right to have access to pictures, videotapes, recordings, documents, witness statements, police reports, etc. Whatever objects, whatever evidence the state has, you have a right to have access to that, or your attorney, your attorney, if you're represented by an attorney, will have access to that. We call that discovery. Now, you also have a right to waive or to give up your right to discovery if you desire to do so. Now, everyone in here who is here for arraignment, you're here, one, you have been arrested and your arraignment date was set today. Now, since you've been arrested, that just simply means that you were in jail and you're out of jail now on bond. You're either out of jail on a cash bond, which means you paid the cash to get out all of the money to bond out, or you're on a surety bond, which means you paid a bond with a percentage of the bond to get out of jail, or you're here on what is called a PR bond, which means you did not have to pay any money to get out of jail. You're out of jail on your own personal recognizance. Now, every day that you have spent in jail, it can be credited towards your punishment. And what I mean by that is every day that you served in jail, for example, if you serve 5 days in jail, you can get 5 days towards your punishment. So for example, let's say the state or the district attorney's office has made an offer to settle your case of 5 days in jail. And that simply means if you have already served 5 days in jail, that means you won't have to serve any more time in jail, because the time that you spent in jail, basically you have already been what we call time served. You'll be given credit for time served, and you would not have to serve any more time in jail on this case. Now, however, if you serve 5 days in jail and they're offering you 7 days, then that simply means you would have to serve 2 days in jail, because you've already have 5 days credit. Every day that you spent in jail also is credited as $100 per day that will go toward your fine and your court costs. If you have 5 days in jail, that's $500 that can go toward your fine and court costs. And so if the state is offering you fine and court costs of $500, you serve 5 days in jail, that means you will not have to pay any more on the fine and court costs, because the time that you spent in jail has already paid it off. Therefore, the fine and court costs will be taxed and retired, which means you won't have to pay it because you've already served your days in jail, and the days in jail has already paid it off. Now, if they are offering fine and court costs of $700 and you stayed in jail 5 days, that means you would have to pay $200. Now, if you can't pay the $200 on the day that you dispose of your case, then the court can put you on what is called a payment plan. You can pay it off in installments. Now, if you do not have the income even to pay it off in installments, then the court can convert your fine and court costs to community service. And what that means is every hour that you do in community service, $12.50 will go towards your fine and court costs. So if you do 8 hours of community service in one day, that's $100 that will go toward your fine and your court costs. Now, Jefferson County has a program for first-time offenders. If you haven't been in trouble before, they have a program that is called pretrial diversion. With pretrial diversion, they put you if you're accepted into the program, Your case is dismissed. And if you complete the program, you can get it expunged from your record. Expunged means wiped off, deleted, or erased from your criminal record. And in order to get into the program, it cannot be an offense involving unlawfully carrying a weapon or resisting arrest. It has to be your first offense, and you have to have an attorney to assist you at writing the application or the letter to get into the program. And again, if you get into the program, it will dismiss the case. If you complete the program, it can be expunged from your record, which means to wiped off, deleted, or erased from your criminal history. If you are a veteran of any one of the branches of the United States military, the district attorney's office also has a program, was part of the pretrial program, that is called Veterans Court. It's for veterans only. Veterans of any one of the branches of the United States military, the only thing you have to do is be a veteran to get in the program. If you get in the program, you'll have the same results. They'll dismiss the case, complete the program. You can get it erased, deleted, wiped off from your record, which means you can get it expunged from your criminal history. Now, this court, Jefferson County Court at Law Number 2, has a program that is called the CSI. It's for short, we call it the CSI program. It stands for Community Safety Initiative. It is a program that I started within the first 100 days of taking this job as a judge. And that program is designed to make Jefferson County a safer place for all of us to live, work, go to school, raise our children, and to go to church. Now, the way the program works is we have partnership with agencies in the community. One of the partnerships that we have, it was with Spindletop. The young people that you see in the jury box, Deputy Hinton and Sarah, they were Spindletop. Deputy Hinton is going to come to you and talk to you a little later about the program that they have at Spindletop. But basically, what Spindletop would do, anyone who has maybe some mental health issues, you don't have to be insane or incompetent, but if you have issues, say bipolar, schizophrenia, depression, anxiety, post-traumatic stress, or any type of mental health issue, they'll be able to talk to you and in a private setting. In essence, there'll be a private interview, and then Spindletop has the capability where they can do an assessment and develop a treatment plan, either outpatient or inpatient, to address your mental health needs. If you have issues with drugs or alcohol, then Spindletop has a program that is called ATAR, and the Alcohol and Drug Abuse Council has a program that is called OZAR. And with those programs, you'll be given a screening. They can do an assessment, and then you'll be referred for a treatment plan, either outpatient or inpatient, depending on your drug or alcohol issues. If you are unemployed, we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with the Lamar University that has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training and a job placement program in the hotel industry, the shipping industry, and the chemical industry. If you're interested in one of those programs, either the hotel industry, the shipping industry, and the chemical industry, you'll be trained in those areas. And once you're trained in the area that you select, then they will assist you at getting a job in the area that you trained in. Now, if you have not graduated from high school, then CICE also has a GED program where they can help you to get your graduate equivalency diploma. And all of these programs that I just mentioned to you are free. It does not cost you anything, does not cost the county anything. Only thing that you have to do is have a desire to be in the program. And if you get into the program, all of these programs can be used as community service toward your fine and court costs. So for example, let's say you're in the program for job training, or you're in the program for mental health treatment or drug and alcohol treatment. Every hour that you participate, or even if you're in there for GED, every hour that you participate in any one of those programs, $12.50 will go towards your fine and court costs, and 1 hour will go towards your community service. So in essence, you'll be doing one thing, but you'll be getting credit for three things. You'll be getting credit for being in the program, you'll be getting credit for the community service, and you'll be getting credit for paying your fine and court costs. So in essence, you'll be killing three birds with one stone. In essence, you'll be doing three things by only doing one thing. And again, all of these programs are free, does not cost you anything. Now, I tell people this all the time, when you come to county court at law number 2, we do not have court as usual. It's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that comes before this court. And we're trying to make a difference in Jefferson County by making Jefferson County a safer place for all of us to live, work, go to school, raise our children, and to go to church. These programs are designed to make productive people. And we believe that if we make productive people have too much to lose, so they will not commit crimes. And the other thing is, in this program, we do not just give time, we take our time. And in essence, we take our time. We don't, as I said earlier, we don't just give jail time or just give time. We take our time because we are trying to make Jefferson County a safer place for all of us to live, work, go to school, and to raise our children. And so the whole point, in essence, in a nutshell, is we do not just arrest the problem, we address the problem. And now, if you're interested in any one of these programs, just let the staff here know, and we'll be happy to assist you and direct you into getting into any one of the programs that you may be interested in. Now, the other thing is the paperwork that you have in your hand. We have people on the staff who will assist you, for those of you who need some assistance, at completing the paperwork. Now, well, and that's going to take us a few minutes to do. But in the meantime, as I mentioned earlier, Deputy Hinton is going to come forward. He's with Spindletop. He's his mental health officer, and he's going to tell you a little something about the program that they have to offer at Spindletop. Deputy Hinton.
Thank you, Ron.
You're welcome.
Morning. My name is Steve Hinton. I'm the deputy licensed by the state of Texas. This is my coworker here, Sarah. Sarah is a qualified mental health professional at Spindletop. The reason we are both here today is because the judge cares about every person here today that's come for his court. The judge has found, more so than not, and statistics prove that people who appear with legal issues commonly have mental health, substance use, or just a lack of community resources that can help you in your particular situation. The judge believes if we can help you with those situations, then we actually get you out of sight of arrest. Now, maybe this is your first time to be here, maybe it's your 10th time to be here. There's still hope. In fact, Sarah has a program, a template in place which can get you plugged in to community resources that will help you with your particular situation. There's one caveat to it. I'm going to ask you to do that today. You may feel uncomfortable, but I ask you to share that need with us when the court goes into recess or visit you. If you'll share that need with us, we can speak to you privately. The information is privately protected. We're not going to tell anybody outside of our conversation without your permission, but it's here to help you. And if there's something that we can provide for you, whether it's job training, whatever it is out there, whether it's mental health, like the judge already said, I want to build on what he explained as well. Mental health doesn't mean that there's something wrong with you. It just means that maybe you have anxiety or depression, things like that, that all of us go through at some point in time. But it's just whether you want to reach out or not at this particular time, and whether it's affected you and whether it's causing maybe some of your legal issues. We want to try to get you out of the cycle of arrest, if that applies to you. If it doesn't apply to you, maybe it applies to a family member you want out, we'd be glad to work with you and get this information through you all to that family member to help you I also have a flyer on the back of it that tells you a little bit about why we're here, what we do in the court, and some of the benefits associated with our program here. But on the front, there's also a 1-800 number, should you ever find yourself in an unsafe place. You can call that number and get help if you need it. And then we get this in everyone's name. There's also a demographic sheet, which I'll ask you to fill out. If you're in the talking to us here in the court, you can do that. If you'll just give us enough information, we'll just call you by phone. The next few days, we will touch base with you and see if you want to talk further. We're not here to harass you about it, but it does give us an option to call you one time. Then you can tell us or share with us what your needs may be, so we can explain to you what options and services that we have for you. If you would see this as value, we'll have those. Figured out here as well. Thank you, Your Honor.
Okay, thank you, Deputy Henry. Now, ladies and gentlemen, earlier I mentioned that if you need any assistance with your paperwork, we have people on the coach staff who will be able to help you with that paperwork. Now, we're gonna come by, they're gonna come by, pick up the paperwork. That's gonna take a few minutes, and then what we're going to do, we're gonna call you up to before the bench one at a time. And when you come up before the bench, make sure that you stand on the X that's on the floor in front of the bench, okay? So at this time, we'll be in recess now. The other thing is, if any of you need to go to the restroom or anything like that, then there are restrooms right outside the door. You can go, because the reason why I'm saying that, this is gonna take a little time for us to go through all of the paperwork, okay? But do not leave the courthouse, because if you leave the courthouse, that means that, you've left, you're not here to finish what you came here for, and so your bond can be forfeited, which means a warrant can be issued for your arrest. So, but we'll allow you to go to the restroom if you need to go to the restroom, or you step outside, out of the courtroom if you need to do that, but need to come back in so we can finalize your case. So at this time, the court will be in recess. And as I said, we'll have some people from our court staff who's gonna come by to help you, assist you with your paperwork. Okay? And Mr. On Zoom, Mr. Cootie, your case, okay, your case is going to be reset to October the 11th. October 11th of 2022. You need to be here in person. So this is a notice that I'm giving to you. It's October the 22nd, excuse me, October the 11th. Yeah, October the 11th of 2022. Okay, do you have that date?
Yes, sir.
Okay, make sure you be here, and our court start at 9 a.m. on October 11th of 2022. So at this time, you're free to go, and you have a blessed day.
All right, you too.